Good afternoon and welcome to Just Jocelyn. I'm so glad that you could join me here today. We're going to do one subject today, one show, but we're going to break it up into two halves only because I need to think in between. I'm definitely not as smart as my guest here, but she is teaching me like a million miles an hour. So as you know, we've got some issues in Nashua. Well, actually, let me back up. We've got issues everywhere in this state. We have issues everywhere in this country. But because we all live here, I think it's important that we know exactly what's going on in the Nashua government. What is happening to citizens, to taxpayers, to all of us that are involved and care about what's happening in our city, in our state. So without further ado, we're going to jump right on into this. And when I get confused, you know me, I'll ask all the questions that we need to ask and to understand. So welcome to the show, Miss Laurie Ortolano. How are you?
Great. Happy to be here.
I'm so glad that you're here. We've talked about this issue, not at length in previous shows. We just kind of touched on it. Policy development, you know, going to court, not going to court. This one comes, that one doesn't come. All the shenanigans that seem to be happening in our courts, which to most people does not seem possible. And you are living the insanity, and so are a bunch of us. So tell me what you want to talk about today. I understand you've done some depositions since we last spoke.
We did. So we're moving forward on a federal trial up in Concord that addresses First Amendment rights, freedom of speech. Up in a court, we have a judge up there that I think is going to lend itself to an interesting trial for me. Okay. It's a jury trial. Oh. And it's in October. So there's a lot of preparation going on for this trial. So there were a lot of parties named in this suit. Mm-hmm. And two were let off. The CFO and the mayor were let off the suit. But I know it's a little disappointing because the mayor could be very much tied in. But he got a pass. But the former chief of police, a deputy, a director of administrative services, the Corporation Counsel for Nashua, the Deputy Corporation Counsel for Nashua, a vendor who did scanning for property record cards for the assessing office, and the city of Nashua are named. So there's like 7 or 8 defendants.
That's a lot.
It's a lot. It's a big case. That's a lot.
Yeah.
So we did some depositions in the middle of May.
Okay.
And my attorney deposed Attorney Bolton, Attorney Leonard, and Mayor Donchis.
Were you in the room?
I was.
How was it?
It was really interesting, I got to tell you.
Good.
It was something to see. The dynamics were very interesting. My lawyer, I thought, was excellent at questioning, really excellent. Good. I couldn't have been more pleased with the line of questioning he did, and also his knowledge and preparation for going in there to do these depositions.
Good. And knowing who he was going to depose.
Exactly. So he knew the significance of these players in the suit and their positions in the city. And, leadership people call the shots, but they often don't own it. When the problems hit, somebody else is responsible.
Right. They pass the buck.
They pass the buck. So trying to dig at where the responsibility lied was the purpose of the depositions, and I think we did pretty well. And one of the things my attorney did was dig out a court order from June of last year in a right-to-know issue I took to court pro se that had to do with this Economic Development Office and this New Market Tax Credit, which is this federal program used to construct the Art Center. And I had put in a very simple petition to Director Cummings to ask for, I wanted to know if they were thinking about doing this again. And he had mentioned that.
Repeat this.
We're going to use this on another upcoming project. And he mentioned it in a board meeting. And I said, I'm not happy about that, but I'd like to know what they're thinking. So I asked him for all potential future projects that there have been communications or documents generated, emails or any type of document that would, where a new market tax credit was being considered. And I'd like the time frame to be a 1-year period. And I picked the 1-year period because the city moved to a cloud-based email storage system that retains for a year. So I picked it because the searching was simple.
Correct.
So,
and they couldn't possibly say, I don't know where that is, or what year was that, or we don't have that anymore, or that's stored someplace else, which is what I find with the fire department.
Right. So I only needed the 12-month search. It was very specific for new market tax credit transaction federal program applying to any upcoming project that Nashua was considering. I got a response back that my request was overly broad, unclear, and they really it didn't make sense, and that it needed to be further defined. And
I don't think it could be any clearer because even I got it. I know. That was not a flyby. I got that. I don't know how you could have gotten any more specific.
And it was such a specific program. So he said, "Oh, I need clarification. And what are you specifically referring to? And could you describe your request more reasonably and in a detailed manner? I'll provide you the information." So I wrote back and said, "Mr. Cummings, I really disagree with you. This is a very specific right-to-know request. New market tax credits are a very specific word to search on.
Right, in the last year.
We've only done one ever in Nashua, so finding number 2 should not be too difficult. So you mentioned you were going to do it on the Elm Street Middle School project, so why don't you start with that file folder, but expand from there."
Yeah.
He writes back and says, "Oh, Mrs. Ortolano, I did a search of the Elm Street Middle School and there were no records in there. But I really don't know what other folders or project files you'd like me to look at. We have all of our projects marked in various folders, and I need to tell you to tell me what folders you would like me to inspect."
Well, I'm sorry, you don't work for the city. You don't work for that department.
No.
So how on God's green earth would you know where Joe or Sally or Sonny put this paperwork?
File. And when he said they keep everything in a folder, he didn't say, I wondered whether it was electronic or paper.
Right, he just said folder.
A folder. Electronic folder or paper folder. I asked him and he wouldn't answer that question. So I said, "Hey, now you're just screwing around with me. Just knock it off. Delay. Do your job. You know exactly what I'm talking about. Do your job." No response. I file a lawsuit. I go into court. I think I filed it in March. And 2 months later, I had a hearing on May 8th.
Okay.
Well, on May 5th, Mr. Cummings gets a lawyer, a Peter Callahan, and he writes a letter to me on May 5th, which is a Friday. The hearing is Monday. And he says, "Oh, Mrs. Ortolano, you know what? We realize that we now understand what you mean, and we've done a search of all the folders, and we have discovered that there are no records for you. There's nothing available." So I go into court on Monday, and we have our hearing. And the judge was very firm about, why didn't you just answer her? It's a very specific issue. You could have just answered her. You really didn't even have to do a search. You knew the answer to this.
Correct.
And the attorney representing Mr. Cummings kind of danced around it. And I was really happy with the judge's overall line of questioning. And I stated that this was ridiculous. This was very clear cut. It was very well worded. The time frame was very defined and current. They didn't have to go to a backup tape or do anything. They were pulling these emails right off the cloud. And we have advanced search capabilities with our cloud software to get this stuff sorted out.
And fast. They could have done that.
Could have done it.
Lickety-split.
So I walked out feeling very confident that I had done well. I'd won.
Dun, 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 dun.
The order comes out. Honestly.
Let me guess.
Honestly, Lynn, I have never understood the court. I have not. I have felt like I've been punched in the face by the court so many times in so many different ways. I do not know and understand what goes on in that court. And it has really shaken my foundation and my belief in the whole judicial system. I really I'm not there anymore. But the order comes out and he writes a pretty blistering order against the city. But he rules that Mr. Cummings provided a letter on May 5th saying that he searched all the records and no records exist. And because your prayer for relief says, order them to provide you with the records, there are no records to provide you, so you lose. Why should I lose when I had to file the lawsuit to figure that out? In federal, under Freedom of Information Act, you'd never lose. If you have to go to court to make something happen,
right,
the other side's liable. Well, what I think happened and I was profoundly disappointed. And believe me, I've lost plenty on things. You're a pro se litigant. You write these motions. You don't really know what you're doing. You lose plenty and you realize, I didn't do that right. That's my fault. This one, I couldn't swallow. I just couldn't. I thought it was just a real kick in the teeth. And the court had encouraged us, myself, Laura Calhoun, to come to court with really clean, focused petitions, single items, nice and tight. Let us look at this and see. This was the perfect one. And the judge comes back 2 months later and says, you lost, but he writes an order. And he says, he summarizes what I wanted. And then he goes on to say that I tried to speak with somebody in IT about it, and they wouldn't answer. And then he says, given Mr. Cummings' May 5th letter essentially stating that there are no responsive records, the court is not entirely sure what is left for it to decide. However, the petitioner has 6 distinct prayers, and he goes through and he says, now none of these prayers apply because they answered you the day before. So,
but isn't that dirty pool?
It's
answering
totally
the Friday before a Monday. Just to clarify for the audience,
terribly dirty
that
pool.
may be their modus operatus, their MO, but to pro se people and the rest of us, when somebody does something last minute, I mean, didn't even the judge say, did you just send out that letter, or are you 100% sure? I mean, where was the checks and balances for that?
It wasn't there, and it was clearly what the judge was doing was he wanted to give the city another chance, but he wanted to give them a firm warning, and his warning was, the court will use this opportunity to address the parties about their highly contentious relationship. Although the court doesn't always agree with Ms. Ortolano or rule in her favor, the court cannot help but join in Mrs. Ortolano's frustration in this particular case. She sought basic information from her local government officials about the potential use of a complex tax credit scheme. Her questions can be boiled down to this: is the city actively exploring the use of new market tax credits for other municipal projects? Mr. Cummings, the chief director of economic development, could have just answered that question with a simple
yes or no.
Right. Based on personal knowledge, as his May 5th letter seemed to suggest. But that would have been too easy. That would have allowed Ms. Ortolano to get what she wanted, and the city surely could not have that, at least not without stringing her along for a while. Thus, here we are again, another right-to-know action involving Ms. Ortolano and the city, another lengthy petition drafted by Ms. Ortolano citing troubling behavior of city employees, another filing fee, another sheriff deputy needing to be served, another attorney hired by the city and paid for by taxpayers, another belated response by the city after the initiation of the case, another merits hearing, another order issued by the court. All of this just to learn that there were no responsive records. And the worst part is that all of this could have been easily avoided had Mr. Cummings answered a simple inquiry posed by a concerned citizens.
That sounds
So the court asked
incredible.
Mr. Cummings, was all of this worth whatever utility you derived from stonewalling Ms. Ortolano? Was it a good use of taxpayers' funds to pay an attorney in this case because you could not bring yourself to answer a yes-no question? Would it have been easier just to answer her question? The court reminds the city and its employees that it is their function to provide assistance to all of their citizens, including Ms. Ortolano, and he cites case law. Indeed, the New Hampshire Constitution dictates that the government should be open, accessible, accountable, and responsive. To that extent, Mr. Cummings and other city officials do not believe that these constitutional mandates apply to them. They are wrong. Thus, the court strongly suggests the city quickly get into the business of responding to Ms. Ortolano's basic questions and requests for information. And it goes on.
Holy cow, that's pretty intense.
Okay, and then it even says, with that said, the court recognized that the city has on many occasions left Mrs. Ortolano with no choice but to file right-to-know petitions. Mm-hmm. And the city does not always engage in any dialogue. Of particular note, the court was dismayed to learn that Mr. Perrin, the city's right-to-know records administrator, included his phone number on his correspondence with Ms. Ortolano and told her to feel free to contact him at the phone number for additional assistance. Yet when she did just that, he told her that he would not directly speak with her. This type of behavior does not meet the responsive and accessible standards of Part 1, Article 8 of the New Hampshire Constitution. And then in the end, he said the undersigned, which was Judge Temple and Judge Colburn, have both asked the city about the process for making a right-to-know request for city records in other cases involving these parties. To date, even us judges have not received a clear answer. The court therefore strongly encourages the city to develop a uniform policy outlining the process for making a right-to-know request for city records, mm-hmm. and to make that policy publicly available on its website. Developing this type of uniform policy would eliminate one of the consistent issues the court sees in the right-to-know litigation involving these parties. Okay, now, you look at this, and if you were the city, what would you do? Would you respond to this? Would you try to clean up your act?
They should, because we're paying their salaries, because the taxpayers and the voters, the registered voters, we instruct our public servants, and that's exactly what they are. Right. And they are acting as dictators, and that that they're immune from everything. They don't have to do as they're told, when it's the exact opposite. And it seems to me that was very, very clear and understandable that they need to clean up their act. You don't have the right to stonewall anybody. And if the public or a taxpayer or a citizen says, I need, I want, may I have, you should say, would you like sugar on the side?
Right. And they turned around the city. So when that happened and I got this order, I was profoundly disappointed for losing because I should not have lost.
No, I mean,
I should have won and he should have
everything.
Right. He did. He said she had to wait until the day before. But then he let them win. So what did the city of Nashua do? They proceeded to not write any policy for 14 months.
So there's still no policy on how to request 91As or right to know.
No.
Anybody.
No.
So they want to do that. There's no policy. So therefore, when there's no set procedure,
right,
then they can throw it out, ignore it, or say it's not correct.
Right.
For any reason.
Right. And so they have decided. So my attorney in the depositions asked Attorney Bolton and Mayor Donchis about this court order. He walked them through all of the lines in this court order. And he said to Mayor Donchis, he said, did you develop policy to go on your website? He said, I don't know. He said, well, what do you think about policy development? He said, well, it's not really that important. And he said, where's my thing? I wanted to find this line and I don't have the right one. So then he said, does it?
And he still,
he said,
to Donchis,
and then my attorney said, don't you think you should have a policy on the city website? And he said, as I've said, something being in writing is not the most important thing. So his response about written policy was, it's not the most important thing.
Okay.
That was how he handled it.
That's very concerning.
Very, very concerning, because you know what it allows them to do? Discriminate against people they don't like.
Yes.
Which has always been an issue for me for 5 years.
It's been nonstop.
Nonstop, and the walls are high now. And when my attorney asked Attorney Bolton and walked him through this case, and he was very clear. He said, my attorney said, all of this just to learn that there were no responsive records. Did the evidence establish that there were no responsive records by the court? And he says, I don't think so. He says, Temple did not. No, that wasn't established. And the worst part, my attorney says, he's reading this. The worst part is that this could have been easily avoided by Mr. Cummings' answer, a simple inquiry posed by a concerned citizen. Do you agree with that statement by the court? I don't think it would have been avoided. He says no. And every time, do you feel that the evidence supported the statement by the judge when he said, Laurie, surely the city couldn't let Laurie get what she wanted? He said, that wasn't part of the evidence. There was no evidence. All of this isn't important to the decision. His decision was in favor of the city. We won. So that's how Bolton looked at this. This was a victory lap.
Right.
Okay? And there was nothing the judge wrote in there that was of any concern to them. Rights of citizens? No. Not a problem. And so these depositions that happened in the middle of May, 1 year after this order was issued, really tell me...
Because you're talking last June.
Right, last June. And now here we are in May.
Yep.
These things actually get printed up and come out in June, and I'm reading them. And there we have these answers clear as anything. And when I came out of my trial in April, and Attorney Leonard was a witness in that trial, I asked her, I said, don't you think having written policy is important for the employees? That the employees themselves need a written policy to understand.
So they know what they're doing, and they can deal with the public, with the taxpayers in an appropriate and consistent manner.
And her answer was, I don't think it's necessary.
So going along with that thought process, well, then I guess it's not necessary to have any policies for anything.
And that's pretty much the way the city works.
And that's not being ridiculous.
No,
they have now said that. So I guess there's no policy on DUIs. There's no policy on having your dog off leash. There's no policy on peeing in the street. There's no policy for, caring when you're not supposed to. I mean, essentially that's what they said. And they poo-pooed the whole importance of what our government's all about.
It should be accountable. And I really think...
Thank you.
FOIA, I did some research and I found this case law. It was Judicial Watch versus U.S. Department of Health, I believe. And great piece of case law last weekend that I read, and I sent it to a friend. I'm like, oh, I wish I'd found this sooner. Well, I didn't realize there's a provision in FOIA, and FOIA mandates that for any Freedom of Information Act issue, every public agency has to have a policy on how their requests are handled. It must be written and it must be in detail what departments it goes to, how it is processed, how emails are processed. There's an accountability that must be done in written policy. That's part of FOIA. Now, I'm going into court in a few weeks to address this issue, and I plan to say that our Constitution, first of all, we have a Constitution in this state that says open, accessible, accountable, and responsive.
And just to be clear, every state has a Constitution, and we also have a federal Constitution. And the point of all constitutions is to protect our inalienable rights, our inherent rights, God's given rights.
Exactly. And what's really interesting about New Hampshire, when I give you Part 1, Article 8, is that New Hampshire is the only state in the country that has the right, public records part of it as its state constitution. I don't believe any other state constitution has public records.
On that.
Okay, I know that I had a friend check, like 36 states did not have it.
Okay.
And we have not found it. And I believe when I attended a Sunshine Week conference that a judge in this state mentioned that we are the only state that has that built into our Constitution. So we've got this extra layer of protection in New Hampshire. And then we've got that constitutional language for open records combined with RSA 91A, which is the more detailed statutory administrative application of open records. And it baffles me that having the belts and suspenders system that we have in this state has been so ineffective in Nashua in getting records opened. It just, and courts in New Hampshire look to other jurisdictions, including FOIA, to seek guidance when they're addressing right-to-know issues.
Correct.
And the fact that FOIA has language that mandates that policies must be in place.
How has that been ignored?
How has it been ignored?
It's been buried. It's not even ignored. It sounds buried.
I think the court had more tools in its toolbox than it has been using. And I think it's time for the court to start using some of those tools. And it's so difficult for pro se people to go in and argue these legal things, while you're building your own little library or your knowledge base. Plus, it's exhausting.
Correct.
I mean, my court experience has been so negative in so many ways because I felt like I always walked into an environment that was ambush. It had booby traps everywhere. And it was because of the nature of the city. They would break rules, stretch, use hyperbole, misrepresent things,
and
delay,
that was everything.
In delay.
Yep. And threaten you, because how many times did they say to you, "I'm calling the police. You can't be here."
Many. So it was, and then it's just this constant feeling of stress that you never lose when you go into court, because you're always on guard. That's you're going to be unprepared, and you're going up against this. In this case for this art center, 5 attorneys, right? It was 5 against 1, so it was really daunting and very stressful. So, I addressed the Board of Aldermen on Tuesday night about policy. I hold the Board of Aldermen accountable for this too.
Well, that's what we're supposed to. That's our duty.
That is our duty.
Where is everybody else?
And I pointed out to them, they have an obligation as a board to work with their constituents. And they are a policy board. That's what they do, legislative work and policy.
Right.
So what prevents them from putting together a committee of some board members and citizens to hammer out some policy for right to know?
Nothing.
Absolutely nothing.
Well, and they have to include the public because they're public servants and we instruct them. And you're instructing them and they're blocking you and ignoring you at every turn.
Right. And this went on, I asked them more than a year ago to do this policy development.
Yep.
But they're waiting for the attorney. They're waiting for Attorney Bolton and Mayor Donches to tell them to do it. That's wrong. They do not need to wait for the attorney. They don't work for the attorney and the mayor.
I was just going to say that. Thank you.
Those people work for the elected body, the governing
Correct.
body. That's our governing body that we elect.
Well, and people need to realize that the power resides with us. And we give, constitutionally, we give the legislative branch, every city, every town, whatever, every state, the authority to do X, Y, Z. But they have to do as instructed, but we also have to approve it. And it seems like they're not following any of these constitutional steps. They're just doing as they darn well please. You know, well, we're going to paint the walls green today, but we don't have to ask anybody, and we don't have to put out a warrant article to spend that money on it because, well, I'm elected.
Right. And they're being led by the nose by officials who don't have the power to lead them, but they've relinquished their power to those people.
Correct.
And that is a very, very big problem in Nashua right now.
Well, it's a very big problem across the United States.
Yeah,
you cannot delegate power that you do not originally have.
Right.
And yet they are, because we did not give you the power to start a committee and then give them the power of the purse, making law or rules, regulations, or the judicial part of it. But yet they're handing that over when they themselves never were delegated that power. That resides in the three branches of government and with we the people.
Yes.
So on that thought, let's take a quick break, regather our thoughts, and we'll come right back. So we're going to take a quick break and we will be right back.